All right, good morning, good afternoon, good evening from wherever you are joining us from across the globe and the continent. We are happy to have you. My name is Leon Senyange. I will be facilitating this session of the Footballer Annual Moot round of 8. The session today is between the Cavendish University, Uganda, as the appellants, and Elizade University, the respondents herein. The chairman of the session is Mr. Ricardo De Buen. He will be having other members of the panel, that is Mr. Tarun Singh and Syed Mohammed. With that, I would like to officially hand the session to the chair for the proceedings to begin. Mr. De Buen, session is in your hands.
Thank you very much. Hello, everyone. Good afternoon or good morning, depending on where you are. So let's begin with the real thing, okay? From now, we are like in a cast hearing. So welcome to the case between Power Stars FC against Netnico Menko and FIFA. I am Ricardo De Buen, the chair of the panel, and I have the honor to have in this same panel Mr. Tarun Singh and Mr. Syed Mohammed. The first thing I have to ask you is if you have any objection regarding the composition of the panel, beginning with the appellant, please.
Yes, I don't know if you can hear me.
Yeah, the appellant first, please.
Okay.
Yeah, following.
We have no objection.
Okay. And now the respondent has any objection regarding the composition of the panel?
Yes, sir, we do, sir.
You have objection?
Yes, Honor. Yes, sir.
What kind of objection do you have regarding the composition of the panel?
Okay. We object to the admissibility of the cast to hear this panel today.
Okay. No, that's different. But just regarding the composition of the panel.
No, sir.
Okay, perfect. And are you comfortable with the way all the proceedings have been so far conducted? Any objection regarding that? Cavendish University appellant?
We don't have an objection, but we intend to make a request.
Okay, let me know which is your request, please.
So our request is that I know we are aware we are supposed to be allocated 15 minutes and 5 minutes for rebuttal. Our request is, if possible, that from the 5 minutes for the rebuttal, if 3 could be given to us on this side so that we can have a comprehensive submission, and remain with 2 for the rebuttal.
Okay, I want you to know the position of the respondent regarding that petition.
Sadiq, yes, you could grant it to them. I have no objection to that.
Objection? So. My colleagues of the panel, do you agree with that?
Absolutely. There's no problem.
Okay. Thank you very much. All right. So we can begin. As you know how many time do you have right now? So the appellant can begin. The appellant has the floor. Please go ahead. Just one thing. As you know, any of the members of the panel could interrupt to ask any questions if they want. We can pose questions. We cannot pose questions if we don't want to. And at the end, if that's necessary or we want to, we will give you some advices and comments regarding your participation. Now,
sir, please, can you hear me?
Yes.
Yes, sir. So we have a PO to raise as the admissibility of the court to hear this matter today. And we don't know if we should start the PO now or the appellant should start their case.
I think that I know that you have the objection regarding the jurisdiction, but for the purpose of this specific competition, I think it is better that we follow the same order. So we have the 15 minutes. They will talk about jurisdiction. and also regarding the merits, and then you have the chance to do the same thing. Is that okay for you? Okay.
Sounds perfect. Thank you, sir.
Just to follow the rules of the competition. Normally, what you're asking for is okay. But if you agree, if I don't have any objection from my colleagues of the panel, can we proceed? Okay. Thank you very much. And I ask everyone to keep their microphone off while they are not speaking. Thank you.
Mr. Presiding Arbitrator, members of the panel, a very good evening on our side. Counsel Daniel Walusimbi is my name, appearing for the appellant in this matter with my co-counsel, Ukubiriza Twak Morgan. As a lead counsel, I'll handle the statement of jurisdiction and admissibility. I'll also handle the issue of whether the FIFA DRC had the jurisdiction to adjudicate and decide the dispute. Then my co-counsel will handle the issue of whether the respondent terminated the contract with or without a just cause, and also will handle another issue of whether the FIFA DRC compensation award was proportionate. And then after, we will render our prayers. So proceeding to my submission on jurisdiction, the appellant submits that this honorable court has jurisdiction to hear this appeal, as enshrined under Article 57, paragraph 1 of the FIFA statutes of 2023, which clearly states that appeals against final decisions passed by FIFA legal bodies must be lodged with CAS. And the same is emphasized under Article R47 of the CAS Code of 2023. So this honorable panel has jurisdiction to hear this appeal. Proceeding to my submission on jurisdiction, on admissibility. Honorable members of the panel, the appellant submits that this matter before this honorable panel is admissible due to the doctrine of force majeure. Generally, admissibility of football matters before CAS are governed under Article 57, paragraph 1 of the FIFA statutes and Article R49 of the CAS Code of 2023, which requires an appeal to be filed with CAS within 21 days from receipt of the decision in question. But the appellant is also aware of Article 15, paragraph 5 of the FIFA procedural rules governing the Football Tribunal of 2023, which obligates the appellant to request for the grounds of the appeal decision within 10 days from the notification of the operative part of the decision. And failure to comply with that timeline will result into the decision becoming final and binding and unappealable. As it was reiterated in the CAS case of Wydad Athletic Club versus FIFA and two others, appeal number 6253 of 2019. And they said, honorable members of the panel, they said Article 15, paragraph 5 of the FIFA DRC procedural rules complements Article 57 of the FIFA statutes, and it must be fulfilled and verified as a matter of admissibility of the appeal with CAS, as held in the CAS decision of Al Wawda Sports Club versus FIFA and another, appeal number 9424 of 2023. So, honorable members of the panel, that being said, from the facts, paragraph 17, line 3, and paragraph 18 of the facts, the appellant is aware that the grounds of the appeal decisions were requested a day extra of the required 10 days, which under normal circumstances will make the decision final and unappealable. But however, in this circumstance, the appellant argues the doctrine of force majeure, which creates an exception to the binding force of an obligation, as it was clearly stated in the CAS decision of Zamalek Sporting Club versus FIFA, appeal number 5779 of 2018, at paragraph 60, at page 13. And in the same case, force majeure was defined as an objective impediment or hindrance beyond the control of the obliged party. With these conditions, that of course it is beyond the control of the obliged party, that is unforeseeable, cannot be resisted, and which renders the performance of the obligation impossible. It is also critical to note that a force majeure, doctrine of force majeure, is not applicable in cases where the party did not act diligently, to limit or prevent the effects of the external interference, as it was held in the case of Betis versus PSV Eindhoven, appeal number 2144 of 2010 at paragraph 41. But this honorable panel, in this present situation, the hospitalization of the CEO of the appellant, which made it impossible to access the email where the notifications were made, and qualifies to be a force majeure because it satisfies all the conditions for the occurrence of the force majeure. And that is, it was beyond the control of the appellant. The sickness and hospitalization of the CEO was unforeseeable. It cannot be resisted, and also rendered the performance of the obligation of the appellant impossible. And also it is critical to note that the appellant acted diligently to prevent or limit the effects of this force majeure, as clearly seen in the facts that actually we took only one extra day to really, perform our obligations. So it is from that premise that the appellant submits that this matter before this honorable panel, it is admissible. Proceeding to my submission on the second issue of whether the FIFA DRC had the jurisdiction to decide the employment-related dispute. Honorable members of the panel, the appellant submits that the FIFA DRC did not have the jurisdiction to adjudicate and decide the dispute because of the existence of the exclusive jurisdiction clause under Article 12 of the contract between the appellant and the respondent, which can clearly be evidenced under paragraph 5, line 1 of the facts. Honorable members of the panel, Article 22, paragraph 1b of the FIFA RSTP grants FIFA the jurisdiction to hear employment-related disputes between a club and a player of an international dimension. But the same article still provides for an exclusive jurisdiction clause, where the parties can explicitly opt in writing that such disputes be determined by a national dispute resolution chamber, as it is in this situation. So, honorable members of the panel, having an exclusive jurisdiction clause means that the dispute can't later be taken to FIFA or CAS unless the National Dispute Resolution Chamber is found not to meet the FIFA standards as laid down in the FIFA Circular number 1010, which has now translated into the FIFA National Dispute Resolution Chamber Recognition Principles of 2024. So in this present situation, members of the panel, the respondent was bound by the exclusive jurisdiction clause under Article 12 of the contract, and therefore he had to refer, as in this matter, to the arbitration committee of the Nigerian Football Federation for adjudication, after giving a 30 days notice to the appellant stating the grounds of the disputes as required under Section D of the framework and rules of the Nigeria Premier Football League, known as the League Rules of 2024-2025. Therefore, it is from this premise that the appellant submits firmly that the FIFA DRC did not have the jurisdiction to adjudicate and decide the dispute, and therefore this decision should be quashed. Honorable members of the panel, having established that the FIFA DRC did not have the jurisdiction to hear the employment-related dispute, I will now yield the floor to my co-counsel to make the submission on issue 3 and issue 4 and further render our prayers. Thank you.
Thank you. As earlier introduced by my co-counsel, Counsel Kuwiliza Twa Morgan, and I'll be addressing issue 2 and issue 3 and issue 4, and later I'll say our prayers. Honorable members of the panel, the appellant submits that the respondent unilaterally terminated the contract without a just cause as required under Article 14 bis, paragraph 1 of the RSTP. and therefore the decision by the FIFA DRC should be quashed. Honorable members of the panel, just cause has been defined as any circumstances which renders the continuation of the employment relationship in good faith unreasonable for the party to give notice, as it was held in a case of Dalian Professional Football Club versus David Cortez and FIFA, appeal number 6992 of 2020. Honorable members of the panel, to determine just cause, two limbs must be made, that is the substantive and the procedural, as it was held in the case decision of Ukrayova 1948 SA versus Marco, appeal number 9444 of 2023. Honorable members of the panel, under the substantive limb, this one deals with the contents and the performance of the contract. Under this very limb, there are two issues or two sub-limbs, which is the material breach and the termination of the contract must be an ultima ratio measure. Honorable members of the panel, material breach occurs only when the main terms and conditions under which the contract was entered into are no longer implemented, as it was held in a case decision of the Hay Football Club versus Ambroise Alien, appeal number 10062 of 2006. In the present situation, honorable members of the panel, the appellant never failed to honor his obligations. He paid the respondent his salaries and only paid him half of the September month because of late resumption. Honorable members of the panel, the ultima ratio measure, this happens, that termination must be the last resort, meaning that the parties have to exhaust all possibilities to address their concern while maintaining their contractual relationship, as held in the case decision of Dalian Professional Football Club versus David Cortez and FIFA, appeal number 6992 of 2020. In the present situation, the respondent terminated after a single letter without genuine attempts to resolve the concern. This is inconsistent with the duty of good faith under the principle of pacta sunt servanda. Therefore, this unilateral termination of the contract by the respondent wasn't ultima ratio measure. Moving on to the procedural limb, honorable members of the panel, the party terminating the contract unilaterally must first put the club in default in writing and grant at least 15 days deadline to comply with its obligation as stipulated under Article 14b, paragraph 1 of the RSTP. Honorable members, as a general rule, following the principle of good faith, giving warning is a prerequisite for terminating a contract because of late payment, as it was held in the case decision of Galatasaray SK versus Frank Ribéry and Olympique Marseille of 2007. In the present situation, under paragraph 15 of the moot facts, the respondent never gave the deadline of 15 days as required by the law under Article 14b, paragraph 1 of the RSTP, but rather through his attorney sent a letter. He just sent a letter claiming bonuses and salary deduction, but he never gave him a deadline, which is required. Honorable members of the panel, as comprehensively discussed above, the appellant firmly submits that the respondent did not have a just cause to terminate his contract. Honorable members, in the event that this honorable court finds it in its wisdom that the respondent had a just cause, I will proceed to submit on the issue of whether the FIFA DRC compensation award was proportionate. Honorable members of the panel, The appellant submits that the FIFA DRC compensation award was non-proportionate as it does not reflect the actual loss as it was held in the case decision of Messina versus El Cacol, appeal number 909 of 2005, and therefore court should review it. Honorable members of the panel, this Honorable Court has the mandate to review the compensation award if they are evidently and grossly disproportionate to the offenses, as it was held in the case decision of Cayespo versus FIFA, appeal number 5588 of 2018. Honorable members, in the current situation, the total amount of the current bonuses, it amounts demanded by the respondent, it amounts to 3.5 million nairas, and even the deduction of the September salary, it is 500,000 nairas. This makes a total of 4 million nairas, but he was granted a compensation of 40 million nairas. This award, honorable members, is not proportionate. Honorable members of the panel, it is our prayer that court set aside and annul the decision issued on the 20th March by the FIFA DRC. On the alternative, if our first prayer is rejected, court should review the compensation award and reduce it to only the overdue payable. Honorable members of the panel, the respondent should bear any cost incurred with the present procedure. I beg to submit.
Thank you very much. Any of my colleagues of the panel has any question for the appellant? No. Mr. Mohammed, any question?
Good afternoon. Yes, I have a question from the appellant. In your submission, you stated that, I want to read exactly what you said. There was no material breach of the contract from the appellant. Did the appellant fully meet all financial obligations to the respondent? And, or maybe in other words, are you saying there were no overdue payments or not? And thank you very much.
Thank you. The appellant fulfilled all these obligations. He paid the respondent his monthly salaries for the whole first year. One, the issue which could be in contention are the bonuses, and of which these bonuses, they were not limited to a duration, and the contract is still running until August 2026, meaning that these bonuses can still be paid along the contract as the contract is still going on. Thank you.
Thank you. Mr. Singh, any question? No? Okay, I have just a couple of questions for the appellant. The first one is, can you elaborate on the burden of proof? How should we analyze the proof that you are and the evidence you're presenting, please? Just very quick.
I beg your pardon?
Can you elaborate on the burden of proof in this case? How should we take care of the evidence as a panel?
As we should take care of the evidence?
Burden of proof.
Okay.
Yeah?
Thank you.
Is the question clear?
Yes, it is clear.
Just a quick answer, please.
A burden of proof should be handled it should be more than a probability of, it must be to satisfy the, how do you call it? It should satisfy the satisfaction of the panel. Rather, it should be more than probability, as in the probability of proof, more than the balance of probability. It should be to the satisfaction of the panel, but not to. Yes.
And who has it in this case? Who has the burden of proof?
It is us. The person who alleges should be the one to satisfy or to prove to the satisfaction of the panel.
All right. Okay. And a second quick question. This is a rhetoric question. if any part of the rule says that you have to give notice in writing, do you think that sending a WhatsApp is writing or not?
Yes, it is. It is a writing. Under the case of, under the case decision of Club A versus B, appeal number 10646 of 2024 at paragraph 67, it was held that the communication via WhatsApp is a permissible mode of communication.
Okay, thank you. Thank you very much. Thanks. Now the respondent has the floor.
Just 1 second, Chair, if I can just have a just a supplementary question.
Yes, please. Go ahead.
Yeah, applicants, just a question of what the chair asked. Is the rule a general rule when it comes to WhatsApp, or in certain circumstances you can only do it? The writing part of WhatsApp.
I beg your pardon?
The question is that if WhatsApp is considered as something in writing, as per the ruling of CAS that you just mentioned, is it a general rule, or in special circumstances only WhatsApp can be considered as a writing, as giving something in writing?
I would think under some circumstances, in case it doesn't show that it is in the control, in the sphere of control of the person that you have communicated to, it will not qualify. But if it shows that it is in the sphere of control of the other party, like for example, it shows 2 ticks, then it is in the sphere of this control, then it will qualify.
Perfect. Thank you. Chair, over to you.
Thank you. Thank you very much. Now the respondent has the floor, please.
Thank you, sir. Thank you for the opportunity. Before this Honorable Tribunal, I am O Oladimeji, and appearing with me is Oba Mishai, our humble appearance for the respondent. May we proceed, sir?
Yes, please go ahead.
Before we proceed to the merit of this matter, we have drafted 3 merits for determination. However, before we proceed to the merit, we'd like to raise a plenary objection as to the admissibility of the court to hear this matter. According to Rule 47 of the CAS Code, Rule 49, Article 15, Paragraph 5, and Article 190, Sub 2B of the Swiss Private International Law, in which the CAS Court is bound by. My honorable panel, in R49 of the CAS Code states that in absence of a time limit set in statute or regulation of the federation, association, or sports-related body concerned, or in previous agreements, then reading it in conjunction with R47 of the same CAS Code, which reads that an appeal against decision of the federation or sport-related body may be filed with CAS if the statute or regulation of the board so provide. Reading this in conjunction with Article 15, Paragraph 5, which states a time limit in which a matter can be brought before the CAS. This time limit is 10 days. And the appellant before this matter filed their appeal a day after. The humble submission that the argument about the CEO being sick doesn't hold water. The argument occurs for you to prove force majeure, there must be an objectivity of unforeseeability. It's a humble contention that the argument of the appellant saying that the CEO was sick doesn't hold water. And if we grant this, it will be a leeway, give an opportunity and excuse for other people to violate this law based on such excuse. It's a humble submission again that the CEO had, he's not the only one running the club. It should have, the other staff could have contacted or have accessed the email, but yet they could, and shouldn't be used as an excuse to violate provisions of this law. In fact, the CAS Court has made it clear that if any other law has made a time limit, and this time limit was stipulated in Article 15 sub 5 of the FIFA procedural rules, and with this, the court cannot proceed. This was to finally cement on this argument. I would like to read the case of CAS 2019A 5 of CAS 2011A 2563 in the case of between CD Nacional vs F Key Sojeska, where the court held that where a party appeal a day or any day after the required time limit, the decision of the FIFA JRC is final and binding and cannot be appealed against. And this reading is in conjunction with Article 190 sub 2b of the Swiss Private International Law, which states that the tribunal would disaward any award given by the CAS if it assumes jurisdiction wrongly. So home submission that this matter here is a wrong jurisdiction and cannot go further. In the interest of justice, it's a home submission that justice must be done though the heavens fall. Our prayer is that this matter is being struck out and our PPO is being upheld before this matter. Thank you. But if you would like to proceed, if you would like me to proceed, I will continue with the merit of my case.
Please go ahead. Thank you.
Thank you. On the jurisdiction of FIFA, Article 22 sub C of the FIFA regulation of the RSTP states that the FIFA has jurisdiction to hear matters of international dimensions. However, it now states that an NDRC can now have jurisdiction if it's independent, if it guarantees fair hearing, and there's equal representation. Now, going further to Rule 2 sub 123 of the FIFA National Dispute Resolution Chamber Recognition Principle, which states that for the NDRC to assume to be independent, there's some condition precedent that must be followed. So I have a submission that this has not been brought before this court or before this matter. Rule 3 sub 1 of that same law states that it is the burden, it is the duty of the member association to prove that the NDRC is independent, is impartial, and guarantees fair hearing. My honorable panel, there is nothing before this court to show that any of these condition precedents has been followed. Going further, that same rule in Rule 2 sub 2 states that for where a member association seeks to use an NDRC for the dispute resolution, it must be officially recognized by FIFA as an NDRC to hear that matter. Once again, there is no proof or nothing before this court to show that the FIFA has recognized the NDRC to hear this matter, to present over this matter. On matter of same jurisdiction, that same law then states that such NDRC must be recognized as an official decision-making body in the relevant laws of the member association. The member association here is a Nigerian club, and there is nothing in reality and here to also show that NDRC in quote exists. So we can't say that the NDRC has shown to be, that the member association has shown that NDRC is independent, guarantees fair hearing, and shows and promotes equal representation, or is even recognized by FIFA. In this case, the FIFA jurisdiction then holds the power, the jurisdiction to hear this matter, and this was submitted in the, and this was held in the case of. So, permit me to read the case. If permit me to read the decision of the case. May I proceed?
Yes,
in CAS 2024, recent case /A1025, in case of Anotrosis Famagusta FC versus Eric Sabo, the court held that for the CFS NDRC to gain jurisdiction, it must comply with FIFA requirements, and the club must provide documents to establish, emphasis on provide documents to establish that or substantiate that the CFS NDRC is independent, guarantees fair hearing, and respect the principles of parity. In this instance case, like I said earlier, there's no evidence to prove that. Moving to my second merit on termination of contract based on just cause. In Article 14b, this can you hear me? Thank you. In Article 14b of the FIFA RSTP, it states that, and also Article 355 of the Swiss law, which states that just cause for terminating contract will exist where the person terminating contract cannot be reasonably seen for him to continue that employment contract in good faith. Article 14b now states that a party can terminate his contract for just cause and then list the ingredient. And this for just cause means that there must be a breach of contract. Salary must not have been paid for 2 months, and he must have sent notice as regards that. Going further, in this instant case, just cause here is the breach of contract, the continuous breach of contracts. There was a contract between NED and the Power FC for payment of his salary and also payment of his bonus fee, but none has been paid. In paragraph 15 of this same fact, the NED sent a letter of demand requesting for his money before terminating his contract. That's been held in criteria of cases that letter of demand serve as a notice. And he has complied with the 15th day. In fact, he even passed the 15th day because he sent this notice on 20th and then terminated on 30th of March and then terminated in October. It's a home submission that that's enough time for the CEO to have responded to his letter of demand. And the continuous breach of contract then cements the fact that there was just cause for terminating his contract. Then if you might permit, I would like to defer to my co-counsel to take merit 3, which is our last merit, and read our prayers before this court. Thank you.
Yes, please. Thank you.
Good day, Honorable Arbitrator. Please, can you hear me? Thank you. I'll be speaking on merit 3. The compensation awarded by FIFA DRC was justified and proportionate in accordance with Article 17 of the FIFA RSTP. The compensation awarded by FIFA RSTP is fair, lawful, and proportionate, and I'm going to state the provision of Article 17 of FIFA RSTP, which provides that party in breach shall pay compensation, and in the absence of a mutual agreement by the parties, the compensation will be calculated in accordance with the following considerations: the law of the country, the specificity of the sport, and objective criteria, meaning, and this can include the remaining time of the contract. Now, it is expedient to note that the positive interest of the injured party must be protected, and this includes the remaining time that the contract, how will I put it? The compensation must consider the remaining time that the contract would have covered, assuming the contract was fulfilled. So the contract was terminated 20th October 2024, and the remaining time was remaining 22 months. And then in the terms of the contract, they agreed to 1 million per month. So 22 times 1 million is 22 million. Not just that, other considerations which include lost bonuses, because this particular player had home wins and he even had away wins, about 10 and 14 respectively. Not just that, not just the lost bonuses, even moral damages and also disruption in the career trajectory of this particular player. All these things need to be considered, and this is even in line with the principle of with the Latin principle of restitutio integrum, which means that the compensation should be considered. It should be considered in line as though the contract would have been fulfilled. I'm going to also state the case of CES 2014/A/3707, where the panel states that compensation should not just be in line with the unpaid salary. Disruption in the player's trajectory should also be considered. And in this dispute, the career of the player was affected. Also, in the case of 2008/A/1519, the panel established that compensation also includes residual value. So, moving on, I would like to read our prayers. The respondents respectively request the Court of Arbitration for Sports, number 1, reject the appeal filed by Power Stars FC and uphold the decision of the FIFA Dispute Resolution Chamber awarding compensation to Ned Kikelo. Second one is to confirm a valid and binding employment relationship existed between the respondent and Power Stars FC based on mutual consent and the parties' conduct, and affirm that the dispute was international in nature and that the FIFA DRC had proper jurisdiction pursuant to Article 22 sub C of the FIFA RSTP. Also, to declare that the respondent had just cause to unilaterally terminate the contract in accordance with Article 14 of the FIFA RSTP due to the club's material breaches, including failure to pay bonuses and unlawful salary deductions. Also confirmed that the compensation of 40 million naira awarded by the FIFA DRC was fair, proportionate, and in accordance with Article 17 of the FIFA RSTP. The fifth one is to award legal costs and any applicable interest to the respondent for the expenses incurred in defending this appeal and enforcing its contractual rights.
Finish? Are you
Yes,
have you
sir.
finished? Okay, thank you very much. Any questions from my colleagues of the panel? Mr. Singh? Mr. Mohammed? No questions?
Yes, Ricardo, please. I have a question from the respondents' councils. The appellant argues that all wages were paid and no overdue amount exists to justify an unilateral termination. As I asked and they replied me that the bonus has no deadline for payment and they are free to pay it until the end of the contract. So how do you respond to this argument?
Yes, sir. So we don't agree to such to the response, because even if the agreement didn't put a deadline as to the payment of the bonuses, the contract has been terminated and it is their due obligation for them to pay the bonus because it was agreed between parties. It's important to mention that in contract, there are 5 key ingredients: offer, acceptance, intention to enter legal relationship. So focus on intention to enter legal relationship. It is a known fact between them that bonuses should be paid, and termination of contract wouldn't oust that fact. And because in the terms of the contract, they didn't stipulate that if the contract is terminated, the bonuses wouldn't be paid. So therefore, they still have the obligation to pay such amount because it has been agreed upon between both parties. Thank you.
Thank you very much. I have a couple of questions. You talk about interests to be paid, and you said the second participant said the applicable interest. Which are the interests to be applied in this case? Which amount, which percentage?
So please, can you repeat the question? I'm so sorry.
Yes, which will be the interest to be applied for this case, for the amount to be paid? If you don't have the percentage, based in which law should we calculate the interest to be paid? Because you said that you want us just to apply the interest to be paid, but the applicable interest, you said. Which are the applicable interests?
I'm so sorry, sir, but please, sir, can you explain the interests? I don't really understand that. I'm so sorry.
Yes. Should we apply 5% of interest, 10%, and based on which law should we apply those interests? Which will be the applicable law to calculate the interest?
Okay, sir. Sir, is it the interest that should be paid for compensation?
Yes.
Yes, sir. Article 17 of FIFA RSTP, sir.
Which are those interests?
Mary, answer the question, sir, if you do not mind.
Yes, any of you
It's
could.
5 to 10% per annum, and as she said, according to Article 17 of FIFA RSTP.
Okay. And the second question is the same I posted to the appellant. Which is the way we have to analyze the evidence in this case?
Again?
Which is the way we should analyze as a panel the evidence in this case? The burden of proof. How should we manage the burden of proof?
Okay, so the burden of proof rests on the appellant because they're the ones that brought this matter to us, and it's a duty to prove beyond reasonable doubt that damages have occurred to them. So it is the duty of the appellant on the panel, sir.
All right. Any other question from my colleagues? Okay, so now you have, if I don't mistake, 2 minutes to rebuttal. The appellant has the floor.
Thank you, Honorable
I
Member.
didn't hear you properly on the time, sir.
Sure. Sorry?
Didn't hear you. Okay, I didn't hear the timing for the rebuttals, please.
For them is 2 minutes, and for you is 5 minutes.
Thanks.
Okay, because they ask to compensate.
I'll use 1 minute. I thank you, honorable members of the panel. The appellant has alleged that actually that I would have used another email that cannot be taken as a force majeure. But for force majeure, it is already approved the CAS jurisprudence that it creates an exception to the binding force of an obligation. But also, please, if I may read it verbatim, paragraph 17 of the facts is very clear. It says on the FIFA legal portal, Nedis Anthony, which is the respondent, used the Power Stars FC COU's email address as the respondent's contact. And if you really wished that that you would want us even to address to that, even you would have put there the Power FC email, not that of only the CEO, but for the club itself. But unfortunately, the email he put there, the CEO was hospitalized, which was beyond the control of the appellant. Then going to the FIFA DRC, the respondent alleged that it did not, the Nigeria National Dispute Resolution Chamber does not meet the FIFA standards. But according to the burden of proof, it is a well-established CAS jurisprudence that any party wishing to prevail on the disputed issue must discharge the burden of proof. But in her submission, he did not discharge that burden of proof. It is just mere allegations. And otherwise, I don't think this honorable panel should act on such allegations without any proof. And also looking at the facts, there is not anywhere that talks about that where you can talk about as in that the Nigerian National Dispute Resolution Chamber does not meet the FIFA standards. I submit to my colleague also to proceed. Thank you.
Thank you.
Your time has ended. 2 minutes haven't.
We request 1 minute.
1 minute, okay. 1 minute of extension.
Oh, thank you, Rabbi.
The other party.
The respondent submitted that the compensation was proportionate. However, she went further to submit that the remaining, when you calculate the remaining amount of the contract, it mounted to 22 million, million nairas, which really is in line with what I was requesting for, that let this compensation be reflect the actual loss, not exceeding the actual loss. Because if you calculate the remaining part of the contract, it is 22 million, and the respondent was awarded 40 million, which is far away. And then going to Article 17, paragraph 1, the respondent submitted that the residue, that the compensation shall be equal to the residue of the contract that was prematurely terminated. That is what is stipulated under the law, but it's not what was done by the DRC. And also that the compensation due to overdues, a player shall be entitled to the amount corresponding to the 3 monthly salaries. But from the facts, they are very evident. They only missed 1 month, that is September, where he was paid half, but the rest of the time, the respondent was paid fully. From the facts themselves, they just show only September why he got a late pay. So where I get a cut pay simply because of late resumption. I submit.
Thank you. Now the respondent has the floor. If you want to use 6 minutes, to be fair, you can use them. Okay.
Thank you very much, sir. Okay, sir, I'll start with my first rebuttal. The appellant claimed that the 14 million compensation was excessive and only overdue bonuses should be payable. Now to our rebuttal. Article 17 sub 1 of FIFA RSTP governs compensation for breach of contract, and it clearly provides, as I've earlier stated, that compensation will be calculated with due consideration for the law of the country concerned, the specificity of the sport, and any other objective criteria. So now breaking it down, first of all, the base salary balance, which is the residual value. Ned has 22 months left in the contract, and that is 1 million per month. So 22 times 1 million is 22 million. Speaking on the second one, unpaid performance bonuses, the contract promised 100,000 per home win and 150,000 per away win. Now, Ned had 10 away wins and 14 home wins from the fact. And if you calculate it, it will be about 3 million. Not just that, also future expected bonuses. Now, compensation under FIFA rules doesn't stop at the unpaid amount. It can also include what he reasonably would have earned if the contract continued. So since he was a regular starter, he had already proven performance, FIFA could reasonably project more bonuses during the remaining 22 months. Also talking about moral damages and career destruction, CAS case allows adding extra compensation when a player's career is destabilized by unfair treatment. And it can be said that the compensation of 40 million naira is proportionate based on the aforementioned point. Now, speaking on another point raised by the appellant, on jurisdiction of FIFA DRC, the appellant claimed that Article 12 of the Employment
I think we lost the signal with her, right? Can you hear me? Yeah.
We can.
Please, can you still hear me? Can you hear me now?
Now we can hear you. We lost your signal. Please go ahead. Please go ahead.
Can you hear me? Okay.
Yes, I
so
can hear you.
as I was saying,
my camera. Go ahead, please.
Okay, sir. Speaking on the second rebuttal, I'm going to go over it. On jurisdiction of FIFA DRC, now our appellants claimed that Article 12 of the employment contract gives exclusive jurisdiction to the NDRC of the Nigerian Football Federation, and thus FIFA lacks competence. But we are of the stand that Article 20 sub B of the FIFA regulation on RSTP expressly provides that FIFA is competent to hear employment-related disputes with an international dimension unless the parties explicitly opt in writing for a national arbitration tribunal that is independent and meets FIFA's minimum procedural standards. Now, CAS 2013/A/3425 Club Atletico versus Andrew held that if a national body does not guarantee independence and equal representation of players and clubs, the arbitration clause cannot hold FIFA jurisdiction. And based on what my other speaker said, they have not proven the independence of this national body. The Nigeria NDRC, although referenced, does not meet the independence requirement set out in FIFA Circular Number 1010 and the FIFA NDRC standard regulation. Therefore, under Article 22 sub B of FIFA RSTP, the FIFA DRC was correct to assume jurisdiction because the dispute was of an international dimension, that is between an Uganda player and Nigerian club, and the NDRC in Nigeria does not fulfill the FIFA's independence safeguards. I'll hand over to my other speaker to continue for the rebuttals.
We lost her. I think we should wait a little bit for her to enter because she's not. Maybe she had some problems with the internet. If you all agree, we will give her just 1 minute just to wait because this happens. Let's wait. I asked my dear colleague in charge of the hearing, we have the colleague from the respondent asking to enter?
No, I do not see any request to enter the session.
Okay, I think we will give her 1 more minute. If not, we can finish with the rebuttal that you already gave us. Okay?
Yes, no trouble there.
Maybe if the respondent can message her to join,
Yes,
and if she's
Yes, thank
sitting
you.
around, if she can come on, yeah,
good idea. Good idea.
yeah. And if she's sitting around you, respondent, maybe she can join you. I think that will be even.
Any answer from her? From her?
No, sir. Sir,
nothing.
should I speak? Should I take
Yes,
apart?
you can
Am I
finish.
permitted?
You please finish. Yes.
Okay, sir. Sorry, sir. So speaking on our last rebuttal, speaking on just cause for contract termination, the appellant claimed that NED had no just cause to terminate salary deductions and unpaid bonuses were not material breaches, and he failed to follow Article 14 of the RSTP's notice requirement. Our rebuttal is that Article 14 of the FIFA RSTP allows a player to terminate with just cause if a club unlawfully fails to pay at least 2 monthly salaries, provided a 15-day notice is given. However, it is expected to note that CAS jurisprudence clarifies that consistent non-payment of bonuses also constitutes a material breach when bonuses form a significant part of remuneration. Now, in CS 2014/A/3704, the panel ruled that persistent failure to pay contractually agreed bonuses amounts to a material breach, as bonuses are integral to a player salaries package. Now, net contract in Article 4 explicitly tied part of his remuneration to performance bonuses. Now, despite playing several matches, winning 24 of them, he received 0 bonuses, which is a major portion of his expected income. Furthermore, the salary deduction of 500,000 without due process constitutes unilateral alteration of contract terms, violating the principle of pacta sunt servanda. On the notice requirement, CAS in CS 2016/A/449 clarified that where a club's behavior shows lack of intent to comply, the notice requirements may be raised. Hence, a pattern of unpaid contractual entitlement, which includes bonuses and arbitral deductions, constitutes just cause, even without the 15-day default notice, because the club's conduct showed unwillingness to honor its obligation.
So I would like to apologize for my network issue. I went off for a few minutes and I apologize for that. Thank you.
No problem. But at the end, we end with the participation of your colleague. That's okay. Thank you.
Thank
And
you.
these things happen with anytime. All right. So okay. Before closing the hearing, I want to ask the parties if they are satisfied of the way this hearing has been held, and if they are comfortable that the right to be heard has been complied by this panel. The appellant, please.
Yes, we have no objection. We are satisfied. All right,
right,
to be
now
heard
the respondent,
was
please.
very relevant to us. Thank you.
Thank you very much. The respondent.
Oh, yes, we're satisfied. However, if I might say something, I would like to clarify that when I was making my PO, I never said that another email should be used. I said that the CEO shouldn't be the only person receiving or using the email. Since it's a football club, the other staffs of the club should have access to the email. So just like to clarify the misunderstanding. Thank you.
That's okay. That should be part of the rebuttal, not now, but okay. It's okay. You gave it a try, and that's good. All right. So after this, my duty is to close the hearing, and following the real thing, we will notify the award as soon as possible to you. Thank you very much for the confidence on this panel, and all of you have a good afternoon. In my case, good morning. This is the end of the hearing. Now we will go through any feedback from my colleagues. Sayed, Tarum, do you have any feedback that you want to? If you want, there's no duty to do it. Please, anything to say,
I think
or should I do it?
Just one thing.
Yes, please.
I want to add, because I've been a part of these kind of moot court competitions when I was a student, so I understand your position. Huge congratulations to both of you. Great attempt. There were some extremely interesting points made by both the teams, and this was great. This was a great evening. I'm going to hit the bed very soon. It's night and it's the night time in India, so it's a great way to end the day. So thank you very much for this. Rasool sir, please, anything from your end?
So good night there. Sayed, any comment?
I want to congratulate both groups. Were really good. As a student, we have to consider that both groups did it perfect. But the thing that maybe it's not good to say it now, but I really recommend you to use your tone perfectly and smart, not just raising that for any kind of reason. Use it as well as you can in working, especially if you want to be a good lawyer. Thank you very much and have a good weekend.
Thank you, sir. Thank you, sir.
Thank you. Now it will be my turn.
It has been an amazing experience. Thank you.
I have been an arbitrator for 23 years almost at CAS. And what I felt today was good. I felt lots of passion in both sides. I like that. The way you were passionate about explaining your cases was very, very good. As Tarun said, when you are in front of moot arbitration, it's not easy. Sometimes you get nervous. In the real world, you may have some more time, and that you don't have here. That is true, but you have to comply with what you have. So in general, some advices that I could give you is when you are citing jurisprudence, first of all, you have to remember that the panel should have read the case before, and they should have, and they will read it after that. That's our duty, okay? So we will have to analyze the jurisprudence, the numbers, and whatever. So what you are trying to do when you are in front of a panel in a hearing is maybe to convince in a specific points, okay? And to focus on a specific points. So be in the side of the arbitrator. If you are hearing lots of numbers, maybe that information won't help to us to decide at that time, okay? So it's very good that you cite jurisprudence, but my recommendation is you cite 1, 2, 3, 4, whatever. If it is a big case, maybe 10. But you focus not on yes, maybe the number, but maybe a little paragraph of the jurisprudence. This is in this case, if we're talking about compensation, paragraph number X of the jurisprudence says that the compensation should be. You did it a little bit, but in some cases you just were naming jurisprudence. It is very good that you have investigated, but my advice is on that. Also, it is important from my point of view that you all seem to understand the case, but just in detail, some of you seem that you were reading some of the part of your explanations, okay? And it is better for us, at least we feel more comfortable. It's not your duty, but it's maybe better for an arbitrator to see that the lawyer is talking to us and knows the case and not reading. So my advice is to look at us, okay? In all the case, look at us and explain the case in that way. That's a better thing to do. Just a few constructive comments. In the case of the appellant, you were not ready to answer the burden of proof. Be careful with that, because then you move but you seem that you were a little bit scared of the question. This is constructive, remember, okay? Because as I told you, both teams did it very good. And you have to be prepared for any question, because for us, if you were talking about burden of proof, because that was what part of of the explanation given by both parties, it's important that you are ready to answer. But at the end, you move and you answer. Maybe it was not the best answer in that issue, but at the end you tried to do it, and that was okay. In the case of the respondent and the first participant, at the beginning you were talking very, very fast. Okay, I know that it is difficult, but when you were talking about admissibility, you were very, 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 very fast. And I think it's better for us to understand that you pause a little bit, okay? And in the case of the second participant of a respondent, she was never looking at us when she was talking, maybe just 1 minute. But it seemed that she was reading, and for us, as I told you, as a panel, it's better to receive your comments looking directly at us. And you also hesitate as a team regarding the interest, because you mentioned the applicable interest. Okay, if you say about applicable interest, you know which are the applicable one. And then you move and give your answer, but you were not very good prepared for that specific question that should be part of your preparation, okay? Remember, this is constructive. It happens in this kind of exercises, academic exercises, and also happens in the real world. So don't worry about it. But our job here is just to be constructive, to use our experience to improve. That's all. Because us as an arbitrator also commit some mistakes or lots of mistakes. That's for true. And as you saw also in the real world, you can have some arbitrators posting lots of questions and some of them not posting questions. In some cases, I don't ask anything because I feel comfortable. And in some other questions, I post lots of questions. And just my final thing here is we arbitrators come from different cultures, okay? Some come from Commonwealth culture and some come from the civil law culture. And we have a different way of asking things, okay? I have learned this in my experience. My first hearings were very difficult for me because I had some Commonwealth colleagues asking the witnesses very hard, and that was not my style. My style was more formal, but at the end, I understood that was the way to get the truth from the parties, okay? So you will get different styles from the arbitrators, and that's good, okay? It has been an honor for me to chair this panel. Thank you, Tarun. Thank you, Sayed, for being part of this. It was great to share. It was an honor for me to share this panel with you and with all the parties and with all the organizers. We will send our notes privately to the organizers, and good luck in the next round. If you're in this one right now, it's a very, very good achievement, and for the next one, very, very good luck. Thank you very much.
Thank you, sir.
Sure, thank you very much, Chair of the panel, Mr. Ricardo De Buen, and our members of the panel, Mr. Tarun, and also Mr. Rasul, and to the participants too. A couple of pointers there coming in from the panel on how we can get the improvements in this particular process. It's a learning process for all of you as the participants, and even I mean, I picked a couple of things there in. I speak too fast, so probably I should also tone down on how fast I speak. But yeah, wonderful session. Thank you very much. And from everybody at the Footballer Annual Mood, we were happy to have this session. It was the final one of the round of 8. And we look forward to those that will make it to the next round, the semifinals and then the finals. And we look forward to having our panel of arbitrators subsequently also in the rounds that will follow. From everybody, have yourselves a wonderful rest of the day, depending on the time of the day you are at in your country. Thank you very much. Till we meet again. Be well and be blessed.
Thank you, sir.
Thank you. Bye-bye.
Okay.
Should you say?
And even